Okay, looks like we're slowing down a little bit, so perhaps I'll get started. Good morning, everyone, and thank you for joining us for today's Navigating COVID-19 webinar. My name is Patrick Sullivan, and I'm the President and CEO of the Halifax Chamber of Commerce. As the province begins to think about lifting restrictions and we begin to shift our focus to more of a recovery phase, the Halifax Chamber is continuing to support our members and the business community by connecting you with the information that you need to make informed decisions. Our community's health and safety remain top priorities, and businesses will need to follow the recommended public health guidelines to keep their customers and employees safe and to prevent further spread of COVID-19. The Halifax Chamber has put together a reopening tip sheet of things to consider while preparing your business for customers, and it is available on our COVID-19 resource page on our website, which you'll find big and bold right off our homepage. I would encourage you and your industry to develop your own sheets that will articulate your opening plans. Dr. Strang has stated that he'll rely on all of us to develop our plans in order to allow business sectors to reopen. I do like to pause though and just remind everyone that of course not all businesses were ordered closed. It was very specific businesses that were ordered closed, although many businesses did close in order to reduce the spread of COVID-19. But as we begin to move towards the next stage of this crisis and begin to plan our reopening, we know there are a lot of questions and uncertainty around rehiring or hiring employees, which is why we're excited to have labor lawyer Brad Proctor back to speak with us today on what we should know as we move to reopen our businesses and rehire employees. Brad Proctor is the leader of the Labor and Employment Proactive Group at McInnes Cooper, as well as the Regional Lead Partner for Labor and Employment at McInnes Cooper. Brad practices management labor law with a focus on occupational health and safety, workers' compensation, wrongful dismissal, labor relations, human rights, and workplace privacy issues. We will have time to answer questions at the end, so please feel free to ask your questions in the Q&A box below, and we'll address them as time allows. So you can fill those questions out at any time. If you are commenting in the chat box, a reminder that there is the option to address your message to panelists, which will only be seen by Brad and myself, or to panelists and all attendees, which everyone will be able to see, which I would recommend so that everyone can see your questions, and other people may have the same question. And thank you very much, Brad, for joining us. I'll turn it over to you now.
Great, thank you, Patrick. And thank you for inviting me back. It doesn't seem like that long ago, and I'm not sure the exact date, but probably about 7 or 8 weeks ago, where I had done kind of session number 1 on the various labor and employment challenges that were starting to emerge in response to COVID-19. Before I start my presentation, I always like to give the little caveat for those that are on the phone that they just understand my background, that I am a lawyer, but as a lawyer, I practice exclusively labor, employment, and occupational health and safety and workers' comp, those types of things. But I'm a management side or employer side lawyer. And so my clients are companies large and small, owner-operator businesses. I am not a plaintiff side lawyer or a union side lawyer. So I just like people to be aware of that so they know the perspective from which I'm presenting. So when I look at this cover slide and I say developing COVID-19 return to work plans, I mean, some of you on the phone, and probably many of you on the phone, as Patrick mentioned, weren't ordered to close. And so when we think about the closures that happened over the last 8 to 9 weeks, you know, in the early days, there were certain industries that were ordered to close. Then there were other industries that weren't ordered to close, but because of a drop in demand for their product or service, or the difficulty in finding staffing and labor, closed or curtailed in some way. So what I'm going to speak to today is kind of generally, you know, resumption of work and trying getting back to a new normal. When we think about the roller coaster ride that we've been on in the last 7 or 8 weeks and what's likely to continue, I was just kind of making a little list here of things that I've been talking about. So it started off talking about layoffs, temporary layoffs. There was some discussions about permanent terminations. There have been some permanent terminations of employment. There's been discussions about changes to employees' hours, changes to employees' duties. about closing the business, about keeping the business open. Safety has been a huge topic of conversation, doing screening questionnaires for employees, temperature checks, personal protective equipment, designing safe work procedures that are specific to the COVID risk, really safety procedures around doing work differently. Then we've had all the legal issues that have come out of employment insurance and creating supplemental unemployment benefit plans. And then came the CERB or the CERB. And then came the Canadian Emergency Wage Subsidy, the human rights issues dealing with employees that need accommodation or that have anxiety issues. And then there's been this kind of general issues about worker morale in some cases with the uncertainty that's been going on. So there's been a lot of legal issues emerge, and some of those are going to continue and become even more important. And there's definitely new challenges that we'll be facing. Next slide, please. So what we're kind of planning for today, we've got an hour scheduled. I'm going to go through a couple of slides really at a high level. My hope is that that takes about 20 to 25 minutes and provides you with kind of some of the general issues. And then I know Patrick has some questions, and then of course there'll be questions from folks. But really what I want to talk about first and foremost is the kind of issue of developing your plan for your particular workplace. We're going to talk about that. I want to then talk about some employment law considerations. I then want to talk about health and safety considerations, some human rights considerations. I'm going to touch on kind of your responsibilities with respect to customers, contractors, and other third parties that might come into your business. Next slide, please. So you might ask, or you might think, why a plan? Why do I need a plan? Well, there's a number of reasons why, I hesitate to say need a plan, but why you should have a plan. And when we talk about a plan, we're not talking about there's a one size fits all or there's a template that you can get. We're really talking about the planning that you need to undertake. And really, it's to allow for an orderly resumption of your operations. I guess what I would say to you as a labor and employment lawyer who's been practicing for about 20 years, and I've also been involved in our law firm, the management of our law firm, for probably about 15 years. And we're a business that throughout 4 provinces employs in the range of 500 people. One thing I've learned is that, it's not always just legal reasons why you should have a plan. There's the employee morale, communication, lack of uncertainty. There's all kinds of reasons that you should have a plan. And so that's something that I'm going to kind of strongly urge. And as we've listened to Nova Scotia Public Health and Dr. Strang, we know that certain industries reopening are going to be contingent on those associations and those industry groups proving to public health that there is a plan to resume that type of business in a safe way. So really, one of the main legal reasons you'll have a plan is we do have a legitimate, bona fide health and safety risk out there. COVID-19 is a health and safety risk, and I don't think anybody would dispute that. We see the number of cases, the number of hospitalizations, and lo and behold, the deaths that occur. And so you as an employer, whether you're a small business or a large business, the legal obligation under the Nova Scotia Occupational Health and Safety Act is that you as the employer ensure a safe and healthy workplace. And that responsibility is shared. It's shared with your employees. It's shared with other contractors that may come into your workplace. But the lion's share of that legal obligation to ensure a health and safety workplace lies on you. And so you have an obligation in resuming operations or continuing operations to think specifically about the COVID-19 hazard, how it impacts how you do business, and how you're going to protect your employees. The other thing we have to keep in mind is that the legal obligation under the Occupational Health and Safety Act, if we look specifically at the wording, it says that you as an employer have an obligation to protect persons at or near your workplace. And as I mentioned earlier, occupational health and safety is a shared obligation, which you share with other parties in your workplace. So I hesitate to say that you have an obligation under health and safety to protect your customers. You do for certain with your employees, but you do have an obligation to look out for them and the hazards that can befall your workplace. There are cases in Nova Scotia where companies have been charged, not with respect to COVID, with respect to third parties or individuals that aren't their employees who got hurt in their workplace. So I do point that out to you. I would say that the standard that you apply is going to be different, but it's not something that you can turn a blind eye to. And lastly, we go back to this whole issue of what's legal and what's just good business practice. If I'm a customer and I come to any type of business, regardless of what service or product you're selling, and I look through the window before I go in the door and I don't see any measures, if I see people crowded together in close quarters, I as a consumer am likely to vote with my feet and say, geez, I'm not going to go in there. So not only does taking health and safety measures, is it good for employee morale, it's good for business. If your customers see that you have put in place visible measures, visible signage, visible protocols for directing flows of traffic or maintaining social distancing, they're going to have confidence and want to go to your business. The next bullet on my slide is I note prove due diligence should you need to. Really, that can happen in a couple of different ways. Number one is if I have a workplace and I bring people back to work and lo and behold, there's a mass outbreak of COVID-19, and the Department of Labor, the Occupational Health and Safety Division, they start looking into it and they find that I've simply done nothing. It's possible that they could say as an employer, I've breached my obligation under the Health and Safety Act to ensure a safe workplace. So if I don't have a plan, if I can't prove that I've turned my mind to this and I have a documented protocol or safe work procedures, proving that I'm defending myself as being duly diligent is going to be very difficult without a plan. In the same vein, if I'm operating a business, and we do know at present there are requirements with respect to social distancing in my business. So if I operate a retail establishment and I am not in any way, shape, or form trying to ensure social distancing and trying to ensure flows of traffic, it's possible that, and it has happened in Nova Scotia, where businesses have been charged. Businesses have been charged with breaching provisions of the Public Health Act and the Emergency Management Act. And once again, if I don't have some paper that I can show that I have turned my mind to these risks and that I'm enforcing it, proving due diligence in that context is going to be very difficult. So, we get to why should we have a plan? Well, we should have a plan because there are elements of the law, occupational health and safety and otherwise, that require it. B, if we do get into legal trouble, either with a Department of Health regulator or with an occupational health and safety regulator, we want to be able to prove that we've been duly diligent and that we've put in place appropriate steps. So that's another good reason to have a plan. And lastly, as I put on the bottom of my slide, we want to manage the expectations of our employees. We are going to see, and we are seeing situations where employees are being recalled and they're saying, I don't know if I want to go back. What do you think is more likely? An employee wanting to come back where their employer has put in place a plan, communicated the plan, and spoken to them about health and safety, or where the employer's done nothing? So managing employees' expectations is a big thing. If you're a unionized workplace, you should work with your union. That is your union as the official bargaining agent for your employees. Work with them and manage their expectations and cooperate with the union. And as well, you want to manage the expectations of your customers. Nothing can be more frustrating if prior to COVID, the business used to operate a certain way, but now because of COVID, there's different access points for my business. There's longer wait times for my business. Those are things that you want to be communicating in advance. If your customers know that in advance, they're more likely to accept those, and their expectations will be managed. Next slide, please. The first thing I want to talk about are some employment law considerations. So basically, what are the various employment issues that we see with recalling people? So the first thing I really want to point out is that when COVID first struck in kind of mid-March, a number of businesses, a number of people on this phone call started implementing temporary layoffs. And those temporary layoffs, we want to be very careful. In many of those, and for some of you and others, I actually had a hand in preparing those notices. We weren't terminating employment. We weren't saying to people, hey, COVID-19 is here, we're permanently terminating your employment. That's not what was said. In many of those notices, what was said was, this is an unexpected experience. It's unplanned for, it's an emergency situation, and we are temporarily laying you off, and we hope to be able to recall you as soon as matters improve. So the first thing you really need to do is you need to look at those letters and those notices that you gave people and determine what you told them. So that's the first point. Because a lot of those people did not sue you, or they did not take you to the labor board because they recognized that you were in the same boat along with every other industry and every other employer in the world. And they said, yeah, we get it. We understand we're being temporarily laid off, and we have an expectation of recall. So when it comes to that situation, we need to look at those letters. The next thing I want to talk about is the changes to terms and conditions of employment. In some cases, many of you did not lay off, but what you did do is you did place people on different terms and conditions of employment. You might have said to them, we're reducing your work week, or we're reducing the number of hours in a day, or we're going to bundle this different set of duties with your job. And once again, you didn't say we're doing this permanently. In many cases, you said this is a temporary measure to cope with COVID-19. And in the other situation, permanent terminations of employment, I didn't see as many of those. There's not as many employers out there that permanently terminated people's employment. It was more often employers that were temporarily laying off, but where you permanently terminated someone's employment then, or you're going to do it now, then that's something we're going to talk about in a little more detail. So let's go to the next slide. So one of the things on recall, and I know on this phone call, it's be difficult to say that we have a uniform group of employers. I would hazard to say we may have an employer on this phone call who's got 3 employees, and we may have an employer on this phone call that's got 500 employees. So you're all very different with respect to what sizes you have of your workplaces. But in any event, you've got to give some advanced planning to this. And that's something that if you haven't done already, you should start. I know in this kind of cycle of COVID, if I were to say that the first 2 weeks were all about layoffs, the next 2 to 3 weeks were all about the CERB and the CEWS benefit. And what I've seen in the last few weeks is employers turning themselves to this planning and recall. And so like in one particular case, to give you an example of what I'm talking about, it was a large workplace with about 800 employees. And as a result of COVID, they basically halved their workforce and laid off, roughly half of their employees, or about 400. And so what they have done is they've recognized in their planning process that demand is not going to return such that they're going to need all 400 people back at once, nor from a health and safety perspective do they want to grapple with 400 people returning on day number 1. So what they've started to do is reach out to employees and gauge through a survey type process to gauge employees' preferences and say, dear employee, we're now starting to look towards business resumption. We're wondering what your preferences are. Is it your preference that you would like to come back at your earliest opportunity? Are you someone who, for whatever reason, would like to stay off for a little while longer? Are you someone that would come back and do a job that's different than your normal job? And so they've been doing that with their workforce to gauge a list of people's preferences. And in those letters, they've said to manage expectations, we're not going to be calling all 400 people back on one day. It's going to be a staggered return. And the other thing that they've said is that at this stage, we're simply gathering your preferences, but ultimately it will be us as your employer who will make the determination as to who comes back when, based on the needs of our business. So that's one thing that I've seen done. There's a little a nuance I have to add to that with another workplace I've been dealing with, which is unionized. And in non-union workplaces, what I've just described, doing the survey, getting employees' preferences, making that determination as to who you need when, based on your business needs, that's your management right to do so. When it comes to unionized workplaces, there's a little additional caveat, and that is you have to look at your collective agreement. You have to look, because in most collective agreements, I would say probably 99% of collective agreements, 99.9% of collective agreements are based on the notion of seniority, meaning that people get laid off in reverse order of seniority. Usually the most junior people go first. And when it's recall, people get recalled in order of seniority. So the most senior people get recalled first. And sometimes there are seniority lists that are based on plant-wide seniority lists. Sometimes they're on department. Sometimes there's language that says that employers can recall based on operational needs, and then where all things are equal, seniority governs. But you do need to look at your collective agreement and adhere to the provisions with respect to recall. And most collective agreements as well, maybe not 99.9%, but 90% of collective agreements stipulate what happens when an employee doesn't come back in response to a recall notice. So in many collective agreements, it will say that employees who do not return to work within 5 days of receiving a recall notice, forfeit their seniority and are terminated. So, collective agreements, you really do need to look specifically at the wording. And, I have, in the last 2 weeks, assisted certain employers with putting in place surveys and letters for unionized workplaces, working with the union, because we've gone to the union in that case and said, look, we want to respect employees' preferences in this workplace, and we understand there may be some employees that are more senior who want to stay off longer. So, we're gonna put this protocol in place where we gauge preferences, but we don't want grievances, either policy grievances or individual grievances. So you can cooperate and work with your unions on those types of things. The other thing you need to keep in mind, and Patrick made this point at the very start, Patrick said, keep in mind, a lot of you on this phone call haven't been ordered to close. And I know when I presented to this group 6 or 7 weeks ago, I cautioned people about getting their source of information exclusively from the news. The news has been invaluable, and I don't want to be perceived in any way as criticizing the news, but when news, depending where you get your news, often it's an aggregation of what's happening nationally, or it may well be based on what's happening in Alberta or happening in Ontario. And so if you're watching, if you're reading the Globe and Mail, or if you're watching the CBC Newswire, and they're saying essential services, this, that, that may very well be based on Ontario's legislation. And I can't stress enough how different the provinces have been with respect to what has been ordered to close, how they're managing their borders, how they're going to be reopening. So make sure what you're looking at is Nova Scotia-based emergency directives, Nova Scotia Labor Standards Code. And similarly, if you're like many employers that operate in multiple provinces, don't apply the Nova Scotia law to the situation in New Brunswick, because they're very different. So make sure you look at the employment standards in your specific jurisdiction. Next slide, please. So changes to terms and conditions of employment. And so in the recall process, it may well be that there's going to be certain changes to terms and conditions of employment that I'll characterize as minor, and I'll characterize as temporary. Examples would be, and we'll talk about health and safety in a moment, but for example, if I have a workplace that works out of Duke Tower, or works out of Purdy's Wharf, or some other workplace, and everyone starts at 9, and I have 300 people showing up at 9, well, from a health and safety perspective, it's going to be hard to enforce the social distancing in elevators and in stairwells and in hallways and in coffee rooms. So it may well be that one of your measures as part of your plan is to stagger people's start times, so that you don't have this one big volume of people coming through the door at the same time. So those would be changes to people's terms and conditions of employment that I would call minor. So if I say to Johnny, my employee, Johnny, you usually start at 8:30, but because we're staggering start times, you're starting at 8:15, and so-and-so, Sally, she's starting at 8:45. Those are minor temporary changes. And I think if Johnny or Sally having their start time changed by 15 minutes, if they said, oh, you've constructively dismissed me, you've unilaterally changed my terms and conditions of employment, I wouldn't think that their chances in court on that basis would be very strong. So those minor and temporary changes, I would argue, are not only expected, but in some cases are required under our obligations for health and safety to ensure a safe workplace. So I do not think that those minor changes that we're going to put in place that are safety related are going to expose us to constructive dismissal. However, where we make changes that are of a more material nature, so not minor, and permanent, that's where we risk constructive dismissal. So where we say to someone, look, Johnny, you used to work 40 hours a week, but lo and behold, in the last 9 weeks, we've learned that we really don't need 40 hours a week for what you do, and we only need 20, so we're making you a part-time employee, that's where you may risk a constructive dismissal. Permanent material changes to hours, to duties, that could expose individuals to a constructive dismissal. And so, and what I am suggesting is, and it's not to say that you still can't come up with a process or a plan to do that. In fact, I've helped individuals who, let's be frank, many businesses have come to realizations in the last 8 to 9 weeks that, wow, we don't need that job, or we don't need as much of that job. And so I have assisted employers in right sizing and in making those changes. And so that's something that if you're going to do, I do suggest you speak to your legal counsel, because they'll advise you on appropriate notice parameters, how to do things in writing, how much advance notice to give people, of those types of things, to minimize or avoid the risk of constructive dismissal. Next slide. And then kind of in that same vein, many businesses, and I literally just got a lawsuit in yesterday from a plaintiff side lawyer, where one of my clients had that realization. They basically realized that we've been operating fine in the last 8 weeks without this particular role, and our industry's been hit. We expect revenues to be down for the next 12 months, and in planning this job is something we don't think we're going to need back ever. And so they've decided to terminate. And in that case, we did receive a letter from a lawyer, and we'll work through that. But that's one of those things where if you're thinking about that, some employers may think, and it's erroneous, that, oh, well, when we temporarily laid people off, we just don't have to call them back. In many cases, those employees that are out there on temporary layoff, remember, go back to the letter you gave them on day one. It said it was a temporary layoff. It said that there would be an expectation of recall. They're kind of relying on your good graces that when things get better, they're coming back. So if you're not planning to bring them back, then they have up to about 2 years, it's the statute of limitations, to sue you for constructive dismissal. So just because they're out there now does not mean they've been permanently terminated. So if there's someone that's out there that's on temporary layoff, and you're now making the decision that, well, I don't think we need them back permanently, what I'm suggesting here on your slide is, number one, review what you said to them on temporary layoff. That's a starting point, because it may well be that you might have said, you might have made it more permanent, depending on what you said in that letter. Secondly, look at your employment contract. What obligations do you have to them as far as notice under that employment contract? And you're going to need to consider what appropriate severances might be if you don't have a written employment contract. On a confidential basis, I will say to you, the angle that I am seeing from plaintiff legal counsel now is, and when it comes to common law notice or severance, there's this unofficial rule, it's an unofficial rule, that a person gets approximately a month notice per year of service. That's where you don't have an employment contract, and that's unofficial. But it gets put out by a plaintiff counsel and relied upon as though it's the law, although it's not. But what we're seeing is we're seeing plaintiff counsel say, yeah, although it might normally be a month per year, in COVID, one of the factors in determining appropriate notice period is the availability of replacement employment, and that is true. In the case law, when you look at what someone's severance is, you look at their age, you look at their length of service, and one of those factors is the availability of replacement employment. And so a lot of these plaintiff lawyers are saying now, because you're releasing this employee into this COVID world, you owe them a bigger or higher or greater severance. And we don't have court decisions on that yet, but it is something that is arguable, because if you think about it, when you release an employee, the purpose of the severance package is supposed to bridge them to getting a new job. And so we know, and I can tell you, if we look at the job wanted ads now online, or you ask yourselves how many of you are looking to hire, it's a pretty slim job market. So the likelihood of a person who's now being terminated permanently in this job market staying off is significant. So that's something that we are seeing from plaintiff lawyers. And like I said, I got a letter yesterday with this whole 2 pages worth of case law on this whole availability of replacement employment. Next slide, please. So I'm shifting in my discussion now from the employment law concerns to the health and safety concerns. And as I've already alluded to, there's no dispute that what we're dealing with is a massive health and safety risk. And so what I've kind of depicted here on this slide is it's a kind of a reverse triangle. And it's a reverse triangle that is what we call the hierarchy of controls in controlling hazards or risk in the workplace. And so if we start at the top of the triangle and we see the larger blue part, in a perfect world, if we want to get rid of a risk or a hazard in the workplace, we eliminate it. We eliminate the hazard, we eliminate the risk, and we don't have to worry about it. What I'm suggesting is that, and if we look at the green one, we can substitute, if there's something that's dangerous or risky, if we can substitute that hazard or that risk, then similarly, we get rid of it. And so what I'm suggesting is when it comes to COVID-19, for those folks that are on this call, the availability of you to either eliminate the risk of COVID-19 or substitute it is next to minimal. And so or impractical. So it's very difficult to eliminate or substitute the risk of COVID-19. So as we descend in the triangle, the next thing we think about are engineering controls. And that's where we're going to try and isolate people from the hazard. There's administrative controls. That's where we're going to change the way people work. And then at the very bottom of the triangle is, of course, personal protective equipment. And for those of you that are on the call that have a safety background or are safety consultants, you'll always say that, what you want to do as an employer when you're doing your safety planning, you want to kind of start at the top of the triangle. It's always better if you can eliminate a hazard as opposed to, keeping the hazard in the workplace and simply giving someone PPE. So you try and work your way up the triangle as much as possible. And I want to be cognizant that Patrick has questions and answers. So the next couple of slides I'm going to go over fairly quickly. Oh, and by the way, on this slide, you'll see that I've got the triangle noted there. On the slide at the top, there's it says embracing the new normal, work safe NB. I found, and this triangle is actually in that document, not this exact version of it, but a version of the triangle. But that document was put out by WorkSafe New Brunswick, and it's a multi-page, probably about a 30-page guide on this process and designing safety plans. And there's also a Word document that you can print off from WorkSafe New Brunswick to actually create a safety plan. I did not have the time, and it didn't jump out at me as quickly that there's an equivalent Nova Scotia workable Word document. Someone on the call may point out in the chat if there is, and we can broadcast that. I just wanted to point out that in New Brunswick there is that, which at least gives you some information, some guidance as you're developing your plan. Next slide, please. So when you're developing your COVID-19 resumption plan, here are some tips. Once again, feel free to modify this for your workplace. Take some of these tips, maybe not others, add additional ones, but establish some type of a management team or task force to think about these issues, right? And it's not just a safety issue. Yes, there are safety risks that can get you either charged or sued, but there's also labor risks under your collective agreement. There's employment risks under your employment contracts. There's privacy risks with respect to gathering privacy related information and retaining it. So, establish the management team that's multidisciplinary, that can think about all these issues. And you can see how I'm already describing how certain employment related issues like changing people's start times, changing their break times, changing their lunch times, changing their duties, those are employment contract employment issues, but you can see how they link up to what we're going to be doing as far as safety planning. So get that team together. Most workplaces on this, well, everybody on this call who's an employer would have either a health and safety representative, which is if you're a smaller employer, you have a single safety rep, or if you're a larger employer, you would have a joint occupational health and safety committee. So make sure that in developing these plans that you consult with your safety rep and you consult with your joint occupational health and safety committee. You can do all the planning you want, and you can have the best plan. Like I'm a fan of Seinfeld. If you think about the George Costanza and the Penske file, you can have the most beautifully organized plan that sits in a binder on your shelf, but it's really no good to you if your employees aren't aware of it, it's not communicated to them, and they don't have confidence that you're doing this stuff. So you've got to communicate, and you've got to advise employees. And I can tell you right now, if you're a large workplace, you're going to get a fewer percentage of work refusals and people that don't want to come back to work if you're overtly communicating your safety plans, because employees are going to say, geez, they're doing a heck of a lot here, and I have confidence in them, and yes, I'm willing to go back to work. Once again, communicate to your customers. We have customers just like you do, and we're going to be doing business differently. We're not going to be having all of the clients sitting in boardrooms and coming into our reception and handing off documents. So we want to manage their expectations in advance and say, hey, to help, the COVID risk for you and us, we're doing things differently, and so you should expect, this different service delivery model. So communicate that to your customers. You may be someone who has contractors, particularly if you're in construction. If you're a general contractor in construction, or you're a university, or whatever you may be, and you have contractors and other third parties frequently coming into your premises or onto your workplace, then you have to manage that as the employer. Those individuals, you can't have policies in place that say employees have to be screened to come on the premises, but then let contractors send their employees in unscreened. So you have to think about that. And the last piece of it here is we have to enforce compliance. All of this paper that we generate and these plans are only so good. But if people can skirt the rules or get around the rules or not comply with the rules, then the plan falls apart. So if there are employees that are breaching the rules, then we have to enforce compliance with our workplace rules. Next slide. So this is just, I said I'd speed up a little bit on these slides. So when we think about the hierarchy of controls and things that we're putting in place from an engineering perspective, well, there's the installation of barriers to ensure 2-meter separation. There's redesigning, implementing walkways, promoting one-way travel. There's plexiglass, which, if you have reception desks and things where customers may come to, there's different mail delivery slots and things for receiving packages. There's redesigning your office floor plans. I know a lot of workplaces in the last 5 years have gone to open concept and collaborative team-based working environments. Well, guess what? That's not so good with COVID-19. So if you've got people sitting at one big workstation where they share a big table surrounded by chairs, you're going to need to redesign and rethink social distancing for the next little while. Next slide, please. As we descend in the control triangle, we think about administrative controls. So things like as basic as if you're sick, stay at home, minimizing your face-to-face contact. So one workplace that I worked with does a lot of meetings, and they've said that if you want to have a face-to-face meeting, then you need to get the permission of the boss. Otherwise, everyone else, every meeting is to be driven to WebEx, Zoom, Teams. And if you want to have the face-to-face meeting, then you need written approval. Because why? Well, they're trying to minimize the exposure of the employees meeting together in meeting rooms. And then if they do get approval to have that meeting, there's a particular sign-off sheet that requires that they check that there's been social distancing, that they've been 2 chairs apart, and there's an actual list of the names of people who attended that meeting. And that's for purposes that in the future, if contact tracing is needed, you have a record of who was in that physical meeting on that day. Assigning employees to designated zones. So the other thing to keep in mind is that when you listen to Dr. Strang and you think about what's going on in Quebec and Ontario, the expectation is that COVID is still a contagious virus. It's still going around. So this notion that we're coming back to work and there's no longer any COVID that is not the premise on which this stuff is based. So have an expectation that in returning to work, you may have a COVID positive case in your workplace. And so what I'm suggesting here with the zones situation is you may be an office building. You might take up 3 floors in the Maritime Center. If my name is Johnny and I work on the 10th floor, I should be instructed that I come to the 10th floor, I follow the directional arrows either to the lunchroom at the designated time, or you may not even have them go to the lunchroom, or to the washroom. You've got to let people go to the washroom, but I am not to go to any other zone because my job doesn't require me to do that. And you might wonder, why am I doing that? Well, I'm doing that, 1, to be proactive and preventative. So Johnny is not walking through 3 floors unnecessarily talking to people about whatever he's watched on Netflix. And secondly, if we do have a COVID positive case in that workplace, and lo and behold, it's Johnny, then when we're doing our contact tracing, we know that Johnny has been instructed that he's only to be in zone 1 and use this particular washroom. So we can then go back and say, okay, well, these are the people he may have come in contact with. And that system, I'll tell you, will provide a lot of confidence to your employees, because they'll know, okay, they're doing this for my protection. And you know, if someone in zone 1 is COVID positive, then I have, you know, I'm confident that they weren't on my floor in my zone. And so I'm seeing that in office environments. I'm seeing that in construction zones, in construction projects, saying, you know, your job on this construction site is in this zone, and you don't need to go anywhere else without getting your supervisor's permission. And I'm seeing it in production facilities, where they're saying, you come in through this door, you access this aspect of the production floor, and stay in that zone. So it's preventative, and it helps with future contact tracing. Discontinuing non-essential travel, kind of a no-brainer, and designing new and safe work practices. One that I haven't put on the slide, but I've worked a lot on, is temperature checks or temperature screening. That's something that I've had a number of clients that have implemented and are doing. And there's different ways to do temperature screening. There's either having the nurses at the front door take temperatures. I'm seeing that in larger workplaces. There's machinery you can buy that people put their face into that actually takes their temperature. Or there's kind of the, in the smaller workplaces, what I'll call the honor system, where people are required to take their temperature at home before coming to work, and to kind of certify when they get to work that they've taken their temperature and they're lower than 38 degrees. So there's all kinds of things from that perspective you can do, as well as just simple screening questionnaires. If you're reopening, you know, people should have to answer a screening questionnaire prior to coming. And once again, if you're a large workplace, you may require this be done electronically. I have seen one client that has hundreds of employees that has a daily online screening check that you do. You know, before you come, you can do it on your phone, or you answer, you know, do I have symptoms? Have I been out of the province? No, no, no. And if you answer no, you go in. It may well be that you use the honor system with that screening questionnaire, and you have people do kind of a daily affirmation of this. I know one client actually prepared plasticized versions of the screening questionnaire and said to everyone, stick this on your bathroom mirror, answer these questions every morning, and if you answer no, then come to, you know, no, I don't have a temperature, no, I haven't been out of the province, then come to work. So those are administrative controls. The last slide, I think is close to my last slide, is on simply personal protective equipment. You have to determine what's right for your business based on those risks. Is it N95 respirators? Is it surgical masks, face coverings? Is it latex gloves? You name, is it a face shield? Whatever it may be, you need to do the risk analysis, risk assessment, and determine what is the appropriate PPE. Because as I mentioned, PPE is at the bottom of that triangle. It's our last, if you will, last defensive measure against COVID. And where we can use things higher up the triangle, the administrative controls or the engineering controls, those are always better than the PPE. And they're not mutually exclusive. Obviously, you can overlay PPE on top of engineering and administrative controls. So Patrick, I may have spoken a little longer than I anticipated, but that ends, I believe my next slide is simply the thanks for coming out slide, I think.
Okay, well then I'm going to jump right into, oh, there is another one.
There's one last slide, and this is, I'll make this one last slide. So work refusals. So you're going to have people that don't want to come back to work. And what I have seen in the last, you know, period of time is these range, they're different categories, okay? So I've tried to bullet point here for you the different categories of work refusals that you're going to see. The first is a formal work refusal. What I mean by that is a formal work refusal under the auspices of the Nova Scotia Occupational Health and Safety Act and likely your workplace health and safety policy. That type of a work refusal has a regimented process that you follow. It's a protected type of work refusal. And so I know in my previous presentation, I spent some time talking about the process. I won't do it here today, but it is a regimented legal process that you have to follow, and ultimately could end you up in front of the labor board. The second is an inability to come to work due to illness. So that's where someone, and I've seen have a compromised immune system, and that's, so they say, I can't come, I have a compromised immune system. Guess what? That's not just something someone's making up. That would be a legitimate health issue. And so as a health and safety perspective, you have an obligation for their health and safety, but you also have a human rights obligation to look into that and see if that can be accommodated. The next one is inability to come to work due to childcare. There's a couple of things there. Number one, in New Brunswick and Nova Scotia, when COVID first happened, there were amendments made to the Employment Standards Act and to the Labor Standards Code on the emergency leave provisions. And so if someone is the primary caregiver to someone who needs care because of their health, or to a child because their daycare or school has been closed and there's no other means for the child, then they are considered protected under the Employment Standards Act or Labor Standards Code. And so you just can't say, okay, you can't come to work, you're providing care to your child, you're fired. They're protected under the emergency leave provision. And so that's something that you need to look at. And we know that school is still closed and will be closed until it ends on June 6th. So that's something we need to keep in mind. And there's also human rights liability there as well with respect to the family status protection under human rights. If someone is the primary caregiver to a child who's not in school, there's a human rights protection there. And then there's the category which is, personal preference not to come to work. And that's probably the most often one I've seen is people are either scared. They may be scared because they think they're going to get COVID. They don't have a health condition. They just rather be home because their kids are home, or they're, it's not so bad receiving the federal CERB benefit and they just rather be home. That is not legitimate. That is where you as an employer can sever the employment relationship if it's a matter of personal preference. If you need the person and there's work for them and they don't fall within one of these other categories, speak to your legal counsel before you pull the trigger. But there's a best practice way to go about cautioning that person, giving them the notice of recall, letting them know the consequences, and if they don't want to come back, then you move on and you part ways with them. And I've had a few cases already of that where unfortunately we've got work and we need it, and we can't just let you stay off. We need to hire someone else, and so there's a way to legally go about that. So I think, Patrick, that was my last slide.
Okay, I'm gonna actually jump to the last question first because it picks up, I think, just where you were where you were speaking, which is in regards to work refusals. How do you respond to the reason of financial hardship? For example, they're actually collecting more money on CERB than they would be if they were working for you.
So that falls in that fourth category of not a legitimate reason to stay off. Unfortunately, the way that CERB worked, regular EI is a percentage of what you actually make, and so in some cases the CERB benefit was less than what some high-earning people would have actually made. But in many cases, the $2,000 a month was more than some people actually make. So, no one wants to be laid off, and it's not good. But unfortunately, the fact that you're making more money on CERB than you otherwise would is not a legally protected reason for you to continue on layoff.
Okay, so picking up on that, if they refuse to work and you can then either terminate or you can hire new employees because someone may not be coming back.
Right.
What do you do with the previous employees? Do you have to, at that point, terminate them? Or
so what I would say to you is best practice is, and I have had a few clients that had these initial calls with people verbally. They called me and they said, hey, we called John. I keep using Johnny and Sally. No offense to if there's any Johnnies and Sallys on the phone, but we called Johnny and Sally, and they didn't want to come back. And so what do? Can we fire them? And I said, yeah, you probably can, but you run the risk now as the employer, keeping in mind that in court or in labor boards, courts and labor boards view the employment relationship as an inherent imbalance of bargaining power, meaning if there's ever any ambiguity in what was said, it's always going to be construed in favor of the employee. So the fact that you've done this all verbally, I don't really like. I would have preferred it if you gave a written recall notice. So we papered that over. We said, dear Johnny, on such and such a day, we called you. You told us that you did not want to come back. You told us the reason was you wanted to remain on CERB, or you didn't give us a reason. So we are now letting you know that if you're not back for your shift, within 24 hours of this notice, then we will need to fill your job. And unfortunately, we will consider that you have abandoned your employment, and we'll fill out an ROE that you've quit, and we will fill your job. So, and that gives Johnny, and then say, if we've misunderstood anything, Johnny, and there's some other reason, then let us know. Because if Johnny comes back and says, oh, no, this is a legitimate legal work refusal, or I'm immunocompromised, or I fit within one of these emergency, then we have to look at that as a protected case. But so my advice is to do these things in writing as opposed to verbally, because that way you'll have proof if you're ever challenged.
Okay, great. Another question from Amy: how would you suggest balancing notification around hazards in the workplace? For example, if there's a positive case of COVID, and the maintenance of employee privacy.
So, and sorry, one other thing that's just an afterthought. I don't want to be viewed as saying you have to terminate that person. You might also say in that letter, and so Johnny, because you're not coming back now, we got to go to market, fill your job, and we can't guarantee when we might end up recalling you now. So you don't have to fire them. You could just leave them out there. You might be in an industry where you actually need people. And so you might just say, Johnny, because you're not coming back, we're filling that with someone else. We can't guarantee when you'll be recalled. So that's that. So balancing employee privacy. So that's a very good question. And privacy is something that is very much alive and well. Like, privacy laws have not been amended or suspended. What I would say to you is, the question is different depending on who's asking. So if you are a federally regulated employer, then you are governed for employment law purposes by PIPEDA, the Personal Information of Protection of Electronic Documents Act. That is much more rigorous and regimented with respect to what you can and cannot disclose. I'm going to hazard to guess that very few of you on this call are federally regulated. There's probably a couple, very few of you. And so that's point number one. Point number two is, for those of you on the call that are defined in Nova Scotia as what we call a public body, meaning that you are a Crown Corporation, a Department of Government, a university, then you are governed by FOIPOP, or Freedom of Information Protection of Privacy Act. That is much more regimented as well. And so if you fall in that category, then you're going to be very limited in what you can say. There's going to be a few of you on the phone call that might fit in that category. But 90% of you on this phone call are not federally regulated and are not public bodies. And like, to let you know a little secret, there is no privacy legislation that applies to the Nova Scotia private sector for employment purposes. So that's the first point. So there's no equivalent to PIPEDA or FOIPOP for private sector Nova Scotia employers. That being said, there is common law actions of what we call intrusion upon seclusion. So you don't want to be out there saying, hey, guess what, everyone? Patrick came to work today sniffling and coughing and tested, and this is a picture of him with COVID positive. That would be intrusion on seclusion, and could subject you to a lawsuit. So I guess my point is, if you're a private sector Nova Scotia employer, that's your main risk, is this intrusion on seclusion, which, to the best of my knowledge, is not a common lawsuit that people start. So be balanced and follow best practices, and that's why I come back to having the plan. Because if I can say, dear employees, as you know, when we recalled you, we took additional measures to ensure your health and safety, which included identifying zones in the workplace, signage, directional hallways, social distancing. This was all done proactively, knowing of the ongoing risk of COVID. We write to advise that an employee working in Zone 1 has tested positive for COVID. We have immediately contact traced and notified public health of all employees that person came in contact with. That area is being heavily sanitized. We are satisfied that person working in Zone 1 did not enter into any other zones of our workplace. And so we wanted you to hear it from us. But that's, so that's kind of how I balance that.
All right. Okay. I'm going to try and get you to answer quickly these next few questions. How would you suggest balancing notification? Oh, sorry, I did that one. Privacy. We just did that one. I'm the leader of our COVID task force. Unsure of the first steps to give my team, and their team are spread across New Brunswick, Nova Scotia, Newfoundland. Is there something that you could suggest that they could look at? I did just sort of provide a link to the chamber document, which is kind of that 5 or 6 steps that you might have seen already, Brad. I think you did. Yeah. But is there something else that you could suggest they could use?
No, I think that chamber document, like, the other thing is not to get too complicated. So I have, and I don't know, there's one person that I forwarded the link to invite to this call that I've worked with on a plan. And that's an employer. I don't know if he's on the call. I won't mention his name or his workplace, but that is the plan that I would say is probably the most complex plan in Atlantic Canada. It involves everything from screening questionnaires to temperature checks to air travel protocols, to busing travel protocols, to office, to construction. Like it's complex because they're complex. However, I've also helped a small, I'll say a restaurateur with, something much more basic, which is simply saying, look, we're recalling people to ramp up our takeout, and here's kind of the one pager as to the steps that we're requiring. Social distancing, sanitizing, the daily affirmation screening questionnaire. So I guess by telling you those two different polar opposites, you really have to think, what are our risks? What are people doing? Are they simply coming to an office building? Because that might be the easiest. If they're simply coming to an office building, then it's social distancing, sanitizing, but are they going out and meeting with customers? Are they interacting with third parties? You really need to think about so I would start with your hazards and risks. And after you've identified your hazards and risks, that's where you start saying, okay, well, what safety steps can we put in place? And then after those safety steps, well, how does that impact people's, start times? And next thing you know, your plan is, by following those simple steps, your plan is pretty much written, but before you make it look a little bit glossy.
Okay.
You don't have to complicate.
Would you suggest that it would be best practice for companies to continue having virtual meetings with clients instead of allowing in-person client meetings at the office?
Yes. I mean, right now, we technically right now, you can have meetings. But I think that's, like I said, it's not going to be that in 2 weeks' time or 3 weeks' time, Dr. Strang says, it's all over, go back to business as normal. And, it's expensive to have to lose people. So if I have a person, I've had a number of clients. So in one particular case, I had a client who had a COVID positive employee. And so that person was COVID positive. So they went off, and they were off for, the 14-day period so that they could, convalesce. But there were 16 other people that they were in contact with that needed to be off pending contact tracing and testing. That's very expensive. It's expensive from a management time. It's expensive from a sick time. It's expensive from backfilling with overtime. So you don't want to have, yes, you want to have a safe workplace, but you don't want those expenses. So as I mentioned, that practice I mentioned a moment ago about, saying the rule is that it's virtual meetings. That's the go forward. And if you have some business case or some special situation where it has to be an in-person meeting, then you need to sign off by, whoever the appropriate person is in your organization. That, I would say, should be part of your plan going forward. Because, the last thing you also want to do is infect a client or have a client infect you. Nothing is better for business purposes. And I am shocked and amazed at how much we can get done on Zoom, on WebEx, on Microsoft Teams. I mean, it's really productive.
Yeah, I would agree with you. So another question, what about someone who just says they don't want to come back to work because they're afraid of getting sick?
So one thing that's interesting, I read a statistic, and this is an Ontario statistic, and it's probably about a week old. But in Ontario, in this article, there were 213 people that had filed official legal work refusals under the Ontario Occupational and Safety Act. And guess how many cases the Department of Health upheld and said, yes, this is an official, this work refusal was reasonable. And guess how many cases?
100.
0.
Wow.
So, I guess my point is a lot, and I have had the good fortune of working in a lot of different industries, right? And I've had clients call and say, oh my God, we have to shut down because this is our business and there's no way we can actually send a technician into a house where there's someone who's COVID positive. And so I've had the good fortune of consulting with some leading doctors and physicians in the area of pandemic planning. And you know what? They say, yeah, well, guess what? We've dealt with that situation, and no, a technician can go in and service whatever this piece of machinery is in a person's home that's COVID positive, provided they do ABC. So my point is that what you think at first blush might be impossible or might be a huge risk can be managed. So to answer that person's question, simple fear alone of getting COVID, it falls in that fourth category on my slide of not a legitimate reason to be to be missing work. You have to have a reasonable basis for a legal work refusal or a health condition or fall under the emergency protection statutes that I mentioned. That situation would not, unfortunately, be a legitimate reason.
Okay. And then a final question, although I think we may have just beaten this to death a few times.
And Patrick, one last comment.
Yes.
I have seen. Keep in mind, and I have seen this exact situation. It's not hard for that person, and I hope I'm not giving people ideas. It's not hard for that person, and this could be legitimate as well, to then go to their doctor and come back with a doctor's note. And keep in mind, we cannot diminish the importance of mental health in the workplace. And so you might think that person, they're not physically displaying any symptoms, but you don't know if they have a recognized mental health issue, an anxiety issue, which similarly, if they have and they're giving you doctor's documentation on, you have to accommodate. So I just wanted to point that out. That fear is one thing, but there also is medical conditions which are which are protected. Sorry, go ahead.
Right. I think you might have just touched on that comment, which is the Nova Scotia Human Rights Act protects against discrimination based on an irrational fear of contracting an illness. So I think you may have just touched on that, right?
That's right. And so that's right. And so you're right. That provision has been in the legislation, and it has not been interpreted in the context of a pandemic. To the best of my knowledge. So it's not been interpreted, obviously with COVID, it's been too soon for any cases to get there on that. But as the best of my knowledge with SARS or H1N1, it wasn't interpreted. So it's kind of there's a question mark over what that provision really means. But there is a provision in there that does provide a prohibited ground of discrimination of the irrational fear of contracting a contagious disease.
Okay. And then the final question is, and again, I think we might have covered this, but a business in the service sector, all of our staff are employed on an on-call basis. Some staff simply stated they were not willing to accept calls at this time. We didn't actually lay off any staff as there was not a lack of employment. People were, there were still jobs or work. A number of staff continued to accept calls and have worked through it. And are there any concerns about calling or not calling any of the others back now? And there's no collective agreement.
Right. So one of those situations where, get it all documented and decide what you want to do. But, the same advice is, if you absolutely need them to do the work and they're not doing the work because, and it's not one of those protected categories I've described, well, you would be within your rights to go and hire someone else and possibly separate that person. Okay. If you want to keep them, and you say, geez, it is hard to find good people, and in normal times they're a good employee, then I still think you should document and say, dear person, we contacted you, you've said you're not accepting calls, just so you know, we still have a business to run, we still have demand for our services, so we're actually going to be, using other resources, and when we start to reassign you calls, we can't exactly say, but manage their expectations so that you're in control, so they don't call you next week or next month and say, hey, I haven't gotten a call, I expect to have a call tomorrow. Make sure you document that you're the person who doesn't want to be called. We're managing our business and we're putting these measures in place. So because you don't want to be called and you've not given us a reason, then you'll get called when we call you, basically, in a nicer way.
Okay. All right. No, that's great. Thank you very much, Brad. Well, thank you very much, Brad. Sorry, we got through a lot. I appreciate it. And I hope folks found that worthwhile. Certainly there were a number of questions. So really appreciate that. We're out of time. So again, thanks, Brad. This is becoming a bit of a habit now. Thank you very much for joining us.
Appreciate it, Patrick. And like I said, thanks very much for putting together all of this information. I know I follow your emails and your website, your web chats, and it's been very useful as I think probably the best place in Nova Scotia to find basically COVID information. So thanks for continuing to do that.
Well, that's great. And to let everyone know, we do have all of that information available at our COVID-19 resource page. And we're now starting to also include information on PPE. As businesses start to reopen, they may wish to purchase some PPE. So we're providing that for our members. If any of you are members who have PPE and would like to provide that, please let us know. So we're doing webinars every week, in fact, almost every day. So appreciate you all joining us. Please take a look at our halifaxchamber.com/events page to see a full lineup. We will have recorded this webinar, and it'll be available to all of you attendees shortly on our YouTube channel. So thank you very much, everybody. And thank you very much, Brad. Really appreciate you joining us today. Thanks.
Great. Thanks, everyone.